So if you look at the United States, historically, the Supreme Court has ruled that the government just cannot stop a journalist from publishing a story.
Right? Absolutely.
I mean, even if that story is, highly embarrassing,
Right.
or even if it threatens certain aspects of national security, like we saw with the Pentagon Papers.
Yeah, the classic example.
Exactly. The government cannot step in beforehand and just halt the presses. It's a concept called prior restraint, and it is arguably the single most fortified wall in American constitutional law. But today, we're doing a deep dive into a stack of documents that prove that what the U.S. Supreme Court expressly forbids, a single local family court judge in Florida apparently just accomplished on a random Tuesday afternoon.
It's honestly a staggering contradiction. I mean, you study constitutional law, you look at these massive, towering federal precedents, and you just assume they act as this impenetrable umbrella over the entire country.
Right.
But the primary sources we're examining today reveal what really looks like a glaring, gaping backdoor in the entire American legal system.
A huge backdoor.
Yeah, and a backdoor that doesn't require a team of Supreme Court litigators to unlock, just the right paperwork filed in a local municipal domestic violence court.
And that is the core mission of this deep dive. We're exploring the profound implications of a recent, very highly specific legal event involving an investigative journalist, and how this single event accidentally exposes a massive, largely hidden architecture of, unchecked judicial power operating right under our noses.
Yeah, in local county courtrooms every single day.
Exactly. So for our sources today, we have actual court documents filed in Miami-Dade County. We also have a really passionate video transcript from a judicial reform advocate named Meg. And we have a sprawling, deeply disturbing data set called the Patriot Dossier, along with these presentation slides that connect the dots between high-profile journalism and everyday family law.
But before we go any further, we really need to establish some extremely firm ground rules for you listeners.
Yes, please.
The inciting incident we're analyzing today centers on a legal dispute between two highly polarized, highly visible political figures. That's investigative journalist James O'Keefe and a man named Matthew Tyrmand.
Right. And let me just be crystal clear right out of the gate here. We are taking absolutely no political sides. None.
Zero.
We're not endorsing the views, the politics, the organizations, or, the past actions of either of these individuals. If you are listening to this looking for a political takedown or a partisan defense, you're definitely in the wrong place.
Totally the wrong place.
Our sole focus is on the structural, constitutional, and legal mechanisms described in these source documents.
Because, frankly, the legal precedent being set in this Miami courtroom doesn't just affect polarizing public figures. I mean, the legal architecture we're about to describe is agnostic.
Exactly. Doesn't care who you are.
Right. If the machinery allows for this kind of constitutional bypass, it applies equally to, say, a mainstream legacy newspaper, a local independent blogger, a citizen journalist, or just a regular person going through a bitter divorce.
It really feels like someone discovered a glitch in the legal matrix.
Yeah.
You have all this heavy, ironclad constitutional security at the front door. But someone realized that if you just walk around to the back of the building, find a completely different court, Division I designed for an entirely different purpose, you can bypass the constitutional guards completely.
That's a great analogy.
So let's look at the absolute ground-level facts of the catalyst. We are looking at a stalking injunction in Miami.
Yeah. So the initial filing is a petition from Matthew Tyrmand against James O'Keefe III. But the venue is what makes this so unusual.
Right. The venue is bizarre.
Because if you believe a journalist or a publisher is going to release damaging, false information about you, the established legal route is to prepare for a defamation lawsuit in civil court.
You wait for the publication, and then you sue for damages.
Exactly. But that is not what happened here. Tyrmand filed for a domestic violence stalking order.
And the specifics of this document are they're wild to read. This is filed in the Circuit Court of the 11th Judicial Circuit in and for Miami-Dade County, Florida. But it is stamped specifically in the Domestic Violence Division.
Versus key.
Yeah. We have a motion and order to extend a temporary injunction signed by Judge Marie Elizabeth Mato. And the timeline, I had to read the dates 3 times to make sure I wasn't misunderstanding the legal jargon.
It's shocking.
This order was signed on April 1st, 2026. But the next status hearing, the final hearing, where actual evidence is supposed to be presented and debated, is scheduled for May 11th, 2026.
That timeline is the first massive structural issue we have to dissect here. Because from April 1st to May 11th is roughly 6 weeks.
6 weeks.
Right. We're talking about 6 weeks where a temporary order carries the full crushing weight of the law. It dictates a person's life, restricts their movements, and suspends their fundamental rights. All before any formal evidentiary hearing has allowed the respondent to cross-examine witnesses or, fully defend themselves. This is what the legal system calls an ex parte order.
Okay, so I've heard that term thrown around in legal thrillers on TV. But what does it actually mean in practice? Like, if you're the person receiving this order, what is your reality in that ex parte phase?
So ex parte is Latin for from one party. In standard American jurisprudence, almost everything is adversarial. Both sides get to speak before a judge makes a ruling.
Right, you get to argue your case.
Exactly. But an ex parte proceeding happens when only one side is present. A judge reads a petition from one party, and without ever notifying the other party or giving them a chance to respond, issues a legally binding order.
Hold on, wait. How is that legal?
Yeah.
Doesn't the Constitution guarantee the right to face your accuser and present a defense before the government can strip your rights?
It does, yes. But domestic violence courts and stalking injunctions were created legislatively with a very specific emergency carve-out. They were designed with a noble, necessary purpose, which is to protect people who are in imminent physical life or death danger. The logic is that if someone is actively trying to kill you or physically harm you, you don't have time to wait for a 2-week scheduling notice to have a polite debate in a courtroom.
Obviously, yeah. You need protection tonight.
Right. So the burden of proof is intentionally set incredibly low at the initial stage. Often, it just requires a sworn affidavit from the petitioner alleging a credible fear of imminent harm. The judge, acting out of an abundance of caution, signs the temporary order. Remove the threat first, investigate the facts later.
Okay, I totally understand the emergency logic if you're talking about physical violence. If someone is wielding a weapon, you freeze the situation immediately. But what we are looking at here is a conflict over published journalism, over a news story.
Yeah.
So how does a dispute about investigative reporting get shoehorned into an emergency domestic violence stalking court? I mean, is this just a rogue judge, or is this a known loophole being explicitly exploited?
It really appears to be a highly strategic exploitation of the mechanism. The legal definition of stalking in many jurisdictions has been broadened over the years to include severe harassment that causes substantial emotional distress.
Emotional distress.
Yeah. So the argument being made in these kinds of maneuvers is that the act of investigating, following someone to ask questions, digging into their background, preparing to publish a story that will ruin their reputation constitutes stalking and causes severe emotional distress.
Wow. So they're taking a statute designed to stop a violent ex-partner from showing up at your house with a baseball bat, and they're using it to stop a reporter from showing up at a public event with a microphone.
Precisely. And by doing so, the petitioner completely bypasses standard media law. The mechanism of the temporary restraining order, or TRO, is used to legally paralyze the journalist.
That's insane.
You aren't just threatening a lawsuit.
Yeah.
You are using the coercive power of the state to restrict their speech instantly based purely on an untested ex parte initial claim.
Which brings us directly to the First Amendment implications, which are laid out in the presentation slides we have. There's a slide that explicitly states this order constitutes a prior restraint against O'Keefe's newsroom. And it cites the landmark 1931 Supreme Court case, Near v. Minnesota. If I remember my high school civics class correctly, prior restraint is essentially the ultimate legal taboo.
Oh, it is the absolute third rail of First Amendment law. Prior restraint means the government taking action to prohibit speech or expression before the speech even happens.
Right.
The foundation of American free speech, established in Near v. Minnesota and famously cemented during the New York Times v. United States case regarding the Pentagon Papers, is that you cannot stop the presses. The government cannot say, we think what you are going to print is illegal or damaging, so you can't print it.
Right, because the alternative is to handle it after the fact. If a news organization publishes something defamatory or libelous or completely fabricated, the person who is wronged can sue them into oblivion. They can win millions of dollars in a defamation trial. But that all happens after the public has had a chance to read the information.
Yeah, the American system relies on post-publication accountability, not pre-publication censorship. To get a federal judge to issue a prior restraint order requires a burden of proof so astronomically high it almost never happens.
It's nearly impossible.
The government practically has to prove that publishing the information will lead to immediate, catastrophic loss of life. Like publishing the exact sailing times of troop transports during wartime. It is nearly impossible to get a prior restraint order in a federal court against a news organization.
Which makes this Miami situation so chilling. It's like, if you don't like what a news organization is going to print about you, and you know you will be laughed out of a federal courtroom if you ask for a prior restraint order, you don't even try. You basically pull a fire alarm in a completely different building.
That's exactly it.
You walk into a local county domestic violence court, claim the journalist's investigation is causing you emotional distress under a stalking statute, and suddenly the presses are stopped.
And standard media law defenses are completely neutralized. In a defamation suit, truth is an absolute defense. If what the journalist is printing is true, they win. But in a stalking injunction hearing, truth isn't necessarily the primary issue.
Oh, wow.
The issue is whether the behavior caused emotional distress. A journalist asking very pointed, factual, true questions about corruption could theoretically cause massive emotional distress to a corrupt politician.
Yeah, I'm sure it does.
Right. But if a local judge signs that temporary restraining order, the journalist is gagged, the publication is halted, and the First Amendment is effectively nullified for 6 weeks.
But the constitutional collisions in these documents don't stop at the First Amendment. Let's look at the physical reality of the paperwork O'Keefe was served. We have a document titled Respondent's Sworn Statement of Possession of Firearms.
Yeah, that one is intense.
The Second Amendment angle here is just as stark. And again, regardless of where you stand on the political gun debate, we have to look at the legal mechanics of how this power is applied.
The document is incredibly severe. Under this temporary injunction, the respondent is legally obligated to surrender any firearms and ammunition they possess. They have to fill out this sworn statement under penalty of perjury.
And the penalties listed on this form for failing to accurately complete it or for remaining in possession of a firearm while the temporary injunction is active are staggering. We are talking about potential federal charges, a maximum of 10 years in prison, or a $250,000 fine.
So let's connect this back to the ex parte timeline.
Right, the 6 weeks.
Yes. We are talking about the instant, immediate suspension of Second Amendment rights, enforced under the threat of a decade in federal prison, through a civil administrative process prior to any formal evidentiary hearing. Your property is restricted, your liberty is restricted, and your ability to publish is restricted on April 1st. But your ability to cross-examine the person making the claims against you doesn't happen until May 11th.
The process is entirely inverted. The punishment happens first. I mean, if I'm a corrupt CEO or a fraudster, and I catch wind that an investigative unit is about to drop a massive expose on me, why wouldn't I just go to my local county court tomorrow and file a stalking injunction?
Why wouldn't you?
If all it takes is a sworn affidavit and a sympathetic or overworked judge, I can shut down the story, disarm the reporter, and tangle them up in local court for months.
And that is the vulnerability. It exposes a profound structural weakness in our legal system. We assume rights are protected from the top down, but local courts operate with an immense amount of discretionary bottom-up power. And this is the exact pivot point where the advocate, Meg, enters the story. This is where this deep dive widens dramatically.
Right. Let's bring Meg's campaign into the spotlight. We have the transcript of her video, and it is a fascinating piece of advocacy. She starts with a cold open, looking directly into the camera, and says, quote, "They just silenced a journalist in family court. Here's why that changes everything."
Yeah.
She isn't just reacting to the news. She is pointing out the mechanism.
She emphasizes that the local judge didn't sign the restraining order because O'Keefe had committed a crime or been found guilty of assault or had any kind of criminal record. The judge signed it because a petitioner utilized the structure of the family and domestic violence court system to secure a gag order. Meg literally says, let that sink in. A journalist, silenced, through a domestic violence court.
And her core thesis takes this single high-profile event and applies it to millions of Americans.
Yeah.
She argues that these local courts, family courts, domestic violence courts, probate courts, were originally designed to be the ultimate safety net.
Right.
They were built to protect the most vulnerable people in our society. Abused spouses, children in physical danger, the elderly.
Right.
But she claims they're being systematically turned into weapons to silence anyone who tells the truth or challenges power.
She identifies a very specific, dangerous triad that enables this weaponization. Zero accountability, zero oversight, and zero transparency. We're talking about judges making unilateral decisions behind closed doors that instantly, and sometimes permanently, alter lives with almost no public scrutiny.
Okay, but let me play devil's advocate for a second. We think of courtrooms as public spaces. Like, if I want to, I can go down to the county courthouse right now and sit in the public gallery of a criminal trial.
We can't.
I can watch a murder trial. I can watch a grand theft auto trial. Why do family courts and domestic violence courts operate with this veil of secrecy? Why are the doors closed?
Well, historically, there is a very legitimate, heavily debated reason for it. Family courts deal with the most sensitive, traumatizing aspects of human existence: child abuse, sexual assault, domestic violence, horrific psychological trauma.
Okay, yeah.
The closed doors were originally implemented to protect the privacy of minors. The state didn't want the traumatic details of a 5-year-old's abuse being read aloud in front of a gallery of strangers or reported in the local newspaper. The intention was to create a safe, shielded environment where vulnerable victims could seek justice without their personal trauma becoming a public spectacle or opening them up to retaliation.
Okay, that makes complete sense. You want to protect the victims from further exploitation.
Yep.
But what Meg and her coalition are arguing is that this very veil of protection has slowly morphed into the perfect cover for the abuse of power. Because there are no reporters in the room, because there is no public gallery, and because court transcripts are often sealed or require exorbitant fees to access. Yeah. Which, by the way, we actually saw in the fine print of that Miami court document.
Yeah, exactly.
Because of all that, there is essentially zero real-time public oversight.
Right. Think about it. If a judge in a public, high-profile criminal trial makes a blatantly biased ruling or ignores obvious evidence, there are reporters in the room furiously tweeting about it. There are legal analysts on the evening news breaking down the error. There is immediate, intense public pushback.
Everyone sees it.
Yes, but if a judge in a closed family court makes an arbitrary, punitive, or completely unconstitutional decision, it happens in a vacuum. It happens in total silence. And that lack of transparency makes the entire system incredibly ripe for weaponization by bad actors who understand how to manipulate the paperwork and the procedural rules.
Which bridges us perfectly from Meg's philosophical realization to the hard, terrifying data. Meg argues that the exact legal mechanism we just saw used against a famous journalist, the ex parte orders, the inverted burden of proof, the instant suspension of rights, is allegedly being used against thousands of everyday families across the country right now. And that brings us to the core of our source material, the Patriot dossier. I want to spend significant time on this because the scale of the data is staggering.
The dossier compiles self-reported, documented data from 2,010 parents who claim to have experienced severe system abuse. We are looking at reports involving over 5,000 children who were removed from their homes without what these parents and advocates consider adequate constitutional due process.
Wow.
But out of all the statistics in this presentation, the number that truly stops you in your tracks is the duration of these cases. The data set shows the average separation time between a parent and a child in these disputed cases is 89.7 months.
89.7 months.
I literally had to pause and pull out my phone calculator when I first read that. That is 7.5 years.
It's unbelievable. 7.5 years. If you're listening to this, just think about the lifespan of a child. If a child is removed from home at age 5, they're almost 13 years old before this average separation period ends. That is their entire elementary school experience. It's puberty. It's their formative psychological years. It's an absolute eternity.
It is a total disruption of foundational human development. And the dossier doesn't just present the tragedy. It outlines the exact bureaucratic mechanism that allows an 89-month separation to occur in the first place. They label this mechanism dual system entrapment.
I found the visual of this in the dossier incredibly helpful. It shows a Venn diagram. On one side, you have the family court system, which handles divorce, custody, and visitation. On the other side, you have Child Protective Services, or CPS, which is a state administrative agency that handles abuse investigations. And the overlapping area in the middle is explicitly labeled the trap. The data claims that 40% of the families in their data set, that's 810 families, are caught in both of these systems simultaneously. How does this trap actually function in real life?
It functions as a devastating, self-reinforcing feedback loop. According to the mechanics outlined in the dossier, the trigger is very frequently a false or highly exaggerated CPS report. Often, this happens during an already contentious divorce or custody battle.
Leverage.
Exactly. One partner, seeking leverage, makes an anonymous or sworn hotline call alleging abuse by the other partner. By law, CPS is mandated to investigate all claims. And because their internal policies prioritize immediate physical safety above all else, an investigator can order the emergency removal of the child pending the outcome of the investigation.
Remove first, investigate later. It is the exact same logic as the temporary restraining order we discussed earlier.
Precisely the same logic. But here's where the trap snaps shut on the parent. Once the child is removed by CPS, the state agency, the family court judge immediately uses that pending, unproven CPS investigation as grounds to instantly alter the custody arrangement.
Oh my God.
The parent is now trapped in a dual jurisdictional nightmare. They are fighting administrative hearings against CPS to prove they aren't abusive, while simultaneously fighting in family court just to retain their legal rights to see their kid.
And the dossier makes a crucial point here. The parent is unable to appeal both at once. The systems move at completely different speeds, with different judges and different rules of evidence. And the most terrifying part is how the burden of proof shifts. Instead of the state having to prove beyond a reasonable doubt that the parent is guilty of abuse, which is the standard in criminal court, the parent is essentially forced to prove a negative. They have to prove they are innocent of the allegations to get their kids back.
We have to look closely at the nature of these initiating allegations, too, because the data here is deeply troubling. The presentation breaks down what these parents are actually being accused of. And the claim is that 38% of all allegations that lead to removal are demonstrably false or completely unproven at the time the state takes the child.
38%.
Mm-hmm.
That means nearly 4 out of 10 times a child is physically removed from a home by state authorities in these contested cases. There is no solid, verifiable proof at that moment that any abuse actually occurred.
Right.
The dossier lists the top drivers for removal as false domestic violence claims, malicious CPS reports, and coached claims where a child is manipulated into saying something. I really need to pause here because as someone outside the legal system, this absolutely shocks me. How is it legally, constitutionally possible that there is currently no requirement for independent third-party corroboration before the government takes a child from their home? I mean, if I get accused of a crime, the police need evidence. They need medical records or photographic evidence or independent witnesses who aren't involved in the dispute. Isn't innocent until proven guilty the fundamental bedrock of the entire American legal system?
If you are in a criminal court facing jail time, yes, the state must prove your guilt beyond a reasonable doubt to a jury of your peers. But child protection and family law operate under a civil administrative framework. The standard of evidence is significantly intentionally lower. In many family court proceedings, the standard is a preponderance of the evidence, which legally just means it is 51% likely to be true.
51%, wow.
It's more likely than not. And at the initial emergency removal phase, the ex parte phase we discussed, the standard is even lower. It is often just reasonable cause to suspect the child might be in danger. The philosophical argument from the state is that if they require hard, undeniable medical proof before removing a child, they might leave a child in a fatally dangerous situation while they wait for the test results.
So the state is erring on the side of extreme caution.
Yes, but the shadow side of that extreme caution is what the Patriot dossier exposes. It means that an angry ex-spouse or a vindictive neighbor can make a single phone call, invent a narrative, and trigger an automated, unstoppable state machine that rips a family apart with zero upfront, verifiable proof. The safety net, designed for the most horrific cases of real abuse, becomes a weapon of convenience in a messy divorce.
And what makes this weapon so devastatingly effective isn't just the profound psychological and emotional toll. It's the stark financial reality. This brings us to a really dark realization as we read through these sources. This system isn't just inefficient. It operates as a massive, self-sustaining financial extraction engine.
The dossier provides what is essentially a literal, itemized receipt of the direct costs to a parent fighting to navigate this dual system trap and get their child back. And the numbers explain exactly why families are being decimated. The average total out-of-pocket cost for a parent in this data set fighting these allegations is $94,000.
$94,000
Yeah.
After tax, liquid cash. Who has that? If you are a middle-class listener right now, do you have 94 grand sitting in a checking account ready to deploy on a Tuesday?
Nobody does.
Almost no one does. People are taking out second mortgages, draining their retirement accounts, maxing out credit cards just to stay in the fight.
And the breakdown of where that money goes reveals the perverse incentives driving the system. Out of that average 94,000, roughly 63,000 goes directly to attorneys. Another 8,300 goes to guardian ad litems or child reps, and another 8,700 goes to court-mandated therapy or psychological evaluations.
Let's talk about those attorneys for a second. Why is it costing $63,000?
Because of the mechanism of the billable hour and the per appearance fee, attorneys in family court are typically paid by the hour or every single time they have to show up to court. There is a built-in systemic financial incentive to file more motions, request more continuances, demand more discovery, and just drag the case out for as many months or years as possible.
Right. Imagine this scenario. It's Friday afternoon. The opposing lawyer, representing your vindictive ex, files a completely frivolous 40-page motion making wild new claims. Your lawyer now has to spend the entire weekend reading it, researching case law, and writing a 40-page response so you don't lose custody on Monday morning. Your lawyer bills you $300 an hour for 10 hours of weekend work. That is $3,000 drained from your bank account in 48 hours over a motion the judge might dismiss in 2 minutes on Monday. But the opposing side achieved their goal. They bled you financially.
That is a perfect illustration of what the dossier calls the depletion tactic. It is a war of financial attrition. The cases are intentionally, structurally prolonged, motion after motion, hearing after hearing, until the targeted parent literally runs out of money.
And then there are the guardian ad litems, the GALs. For listeners who might not be familiar with family court jargon, a GAL is usually an attorney or a mental health professional appointed by the judge to represent the, quote, best interests of the child. In theory, it sounds great, an independent voice for the kid. But the dossier points out a massive, glaring conflict of interest in how they operate.
The conflict is in the funding. These GALs are appointed by the judge, but they are almost always paid for by the parents. The court issues an order forcing the parents to pay the GAL's hourly rate, which can be hundreds of dollars an hour.
So a GAL is essentially like a contractor the government forces you to hire to evaluate your own house. But you have no power to fire them, you have no power to negotiate their hourly rate, and if you stop paying them because you ran out of money, they report back to the judge that you are uncooperative, and the government takes your house, or in this case, your child.
It creates a completely closed-loop economy with zero market accountability. The judge assigns the GAL, the parents foot the bill under threat of contempt of court, and the GAL reports back to the judge. The dossier argues that because the GAL is immune from being sued by the parents, there is absolutely no accountability for the quality, speed, or fairness of their investigation.
And if we zoom out to the macro level, the economic devastation is incomprehensible. The dossier estimates that nationwide, this system has extracted $3.2 billion in family wealth.
Billion, with a B.
Yeah. And even worse, they estimate a staggering $10 trillion in lost earning capacity. Because parents are missing work for endless Tuesday morning court hearings, they are losing their jobs due to stress, or they are having their careers destroyed by the mere existence of a pending abuse investigation.
And we have to look at the inevitable result of this depletion tactic. What happens when the $94,000 is gone? The data shows that 50% of the parents in these protracted cases are eventually forced to represent themselves. In legal terms, this is known as going pro se.
I try to put myself in the shoes of a pro se parent. You are emotionally exhausted. You are traumatized by the sudden loss of your child. You are financially ruined. And now you have to walk into a courtroom completely alone. You are facing an opposing spouse who might still have a high-paid attorney. You are facing state-funded CPS lawyers. You are facing the court-appointed GAL. It is a completely asymmetrical war.
It's not even a fight.
No. The insiders know all the procedural rules, they know the jargon, they play golf with the judge, and they can easily use procedural traps to strip a pro se parent of their remaining rights.
The geographic data on where this devastation is occurring most frequently is also fascinating. The dossier highlights that this isn't evenly distributed. The top 10 states account for nearly 48% of all national submissions of system abuse.
Let's look at those state-specific numbers because they paint a grim picture of how different jurisdictions handle these cases. California has 171 cases in the dataset. The average case length there is 69 months, and they track $39.1 million in lost family assets just from those 171 cases.
It's wild.
Texas has an average length of 32 months. Kansas is at 106 months.
But look at Pennsylvania. They have 78 cases in this specific dataset, but the average case length in Pennsylvania is 159 months.
159 months. Let me do the math on that. That is over 13 years. How is a child custody case open for 13 years? A child is born, and by the time the court reaches a final disposition, they're getting their learner's permit to drive.
If we synthesize this back to the constitutional principles we started with, what we are seeing is that the sheer lack of timely due process serves as a punitive measure in itself. Think back to the James O'Keefe document at the beginning of our deep dive. He received a temporary injunction on April 1st, but the final hearing wasn't scheduled until May 11th. 6 weeks of suspended rights without a trial. Now take that exact same mechanism and scale it up to 159 months in a Pennsylvania family court.
The process is the punishment. You don't even need a judge to eventually issue a final ruling against a parent if you can just keep them bleeding in the system for a decade. By the time a judge actually makes a final decision, the child is grown, the parent is bankrupt, and the familial bond is irreparably destroyed by time and distance. The system achieved its punitive goal without ever actually having to prove the initial allegations of abuse in a fair trial.
Which is exactly why Meg and her coalition aren't just publishing a list of grievances. They aren't just complaining about bad judges. They are presenting a highly specific structural blueprint for overhauling the system. They are trying to literally rewrite the source code of local family courts.
Yes, the presentation outlines a massive 12-step solution. And we aren't just going to read this as a dry list, because these proposals represent a fundamental, earth-shattering shift in how local justices would operate. If we group these thematically, let's start with what they call the evidentiary fixes.
The very first pillar of their blueprint is a demand to require independent corroboration before any child removal can take place. They are demanding that a state agency like CPS cannot act solely on an anonymous hotline tip or a bitter spouse's sworn affidavit. There must be independent medical records showing abuse, photographic evidence, or sworn testimony from third-party witnesses before the state can sever the parental bond.
That makes sense.
And furthermore, they argue that CPS can no longer investigate itself. If a parent claims a CPS investigator lied or fabricated evidence, there needs to be an independent external oversight body to investigate the investigator.
This is back to my earlier shock. They are basically demanding that the constitutional standard of innocent until proven guilty be explicitly applied to family separation, ending the remove first, investigate later culture. Then we look at their due process fixes. They are calling for the right to a jury trial for custody modifications. Right now, as we've established, one single judge decides the fate of a family behind closed doors. They want parents to have the right to demand a jury of their peers.
They are also demanding state-funded representation. If the state is utilizing unlimited taxpayer resources to take your child away, they argue the parents must have automatic attorney parity. If you cannot afford a lawyer to defend your family, a competent one must be provided to you exactly as it is in criminal court.
Which would change everything for pro se parents.
Everything. And they want strict, codified restrictions on emergency ex parte removals, requiring documented proof of immediate physical danger and mandatory 24-hour notification to the parents.
Next are the timeline and financial fixes, which directly address the depletion tactic we spent so much time on. They want a hard 18-month closure mandate for all family court cases. No more 159-month nightmares in Pennsylvania. A final disposition must be reached in a year-and-a-half period. They also want to end what they call perpetual reunification.
Right. Perpetual reunification refers to the practice of a court constantly moving the goalposts. A parent is told to take anger management classes, do therapy, and get a stable job. They do all of it. But then the GAL or the judge says, well, let's wait another 6 months and do more therapy just to be sure.
Just to keep the billing going.
Exactly. The blueprint demands a maximum 12-month limit on reunification plans. If a parent completes the mandated steps within a year, the return of the child should be legally presumed. And crucially, they want to halt the financial extraction engine entirely by eliminating per-appearance billing for attorneys and ending the financial conflicts of interest for GALs, perhaps by making them salaried state employees rather than private contractors billing the parents.
Finally, we get to the accountability fixes. And looking at this from a legal perspective, this might be the most explosive, controversial part of the entire blueprint. They want to end judicial immunity for all court actors.
Judicial immunity is a massive legal shield. It means you generally cannot sue a judge personally for a decision they make on the bench, even if that decision was wrong or harmful. The advocates argue that if a judge or a GAL knowingly violates constitutional rights, ignores exculpatory evidence, or acts with blatant malice, they should be stripped of that immunity and held personally legally liable for the destruction of the family.
They are also calling for the establishment of independent review boards to actively investigate abuse of discretion by judges and to publish the reversal rates of those judges. They want mandatory transparency. They are demanding public, quarterly dashboards showing court outcomes, average case lengths, and the total financial costs extracted from families in every single jurisdiction. Movement-wise, we should note they are already pushing this at the state level. Arizona, Wisconsin, and Minnesota have legislative packages put together, and New Jersey, Oregon, and Mississippi are getting close.
Yeah, they're moving fast.
But I have to stop and ask you, looking at this blueprint from a bird's eye view, I mean, this is a monumental overhaul. Does introducing things like public quarterly dashboards, eliminating judicial immunity, and demanding jury trials for custody fundamentally break the nature of family law? I mean, is the system, as it is physically funded and constructed today, even equipped to handle that kind of transparency and procedural rigor?
The short, pragmatic answer is absolutely not. The current system is completely unequipped for it. Local courts are drowning in cases. They rely heavily on administrative efficiency, judicial discretion, and opacity just to process the sheer volume of highly emotional disputes that come through the doors every day. Introducing a jury trial for a custody dispute would slow the system down to a glacial pace and increase state operating costs exponentially.
Right.
Public data dashboards would require a level of sophisticated data tracking and anonymization that most local county clerks simply do not have the budget or the IT infrastructure to execute.
But I imagine the advocates would counter that by saying efficiency is exactly the problem. The system is incredibly efficient at stripping people of their rights and draining their bank accounts.
That is exactly the friction point. It is a fundamental clash of paradigms. The family court system prioritizes the rapid administrative flow of cases and the theoretical absolute protection of the child above all other concerns. The Patriot dossier prioritizes strict constitutional due process and the foundational presumption of parental fitness. To win a legislative battle of that magnitude, to force the state to completely rebuild how it handles family law, angry anecdotes and emotional stories on the internet are never going to be enough.
Which brings us to the final brilliant tactical maneuver of Meg's strategy. Let's go back to Meg's video and her core announcement. She looked at the James O'Keefe case, the weaponization of a domestic violence restraining order to gag a billionaire-backed journalist in 6 weeks, and she realized it is the exact same mechanism used against a pro-se mother in family court. It's just a different application of the exact same unchecked power.
And because she made that connection, she is expanding the scope of her entire operation. The presentation makes it clear it is no longer just about family court. It is about all local courts. Custody battles, journalist silencing, probate court abuse where the elderly are drained of their estates, civil disputes. The underlying mechanism is always the same. Unchecked judges operating in a vacuum with no accountability, enforcing a system where the process itself is the punishment.
So she is calling for anyone who has experienced this in civil court, probate, domestic violence court, anywhere, to submit their data. But here is the crucial detail that elevates this from a viral internet campaign to a massive, credible institutional threat. She has officially partnered with a researcher from Johns Hopkins University to process this data.
The importance of that partnership cannot be overstated in the realm of policy change. Why does Johns Hopkins matter? Because the legal establishment, the judges, the state bar associations, the local legislatures can easily dismiss a stack of internet surveys. They can wave it away as a collection of angry parents venting online. They label it anecdotal.
Right, the politicians just say, oh, those are just bitter ex-husbands and ex-wives complaining because they lost custody. It's not a systemic issue.
Exactly. But you cannot wave away peer-reviewed academic data published by a researcher at one of the most prestigious medical and research institutions in the world. Transitioning from qualitative, emotional anecdotes to quantitative, academically validated data is the only viable path to force real legislative change. As Meg says in her video, this data is becoming a weapon for change. It moves the conversation from the fringe right into the halls of the state capitol.
It is the difference between a rumor and a diagnostic MRI. Once the data is published academically, it becomes a documented, undeniable systemic failure that lawmakers are forced to address or risk being complicit.
And this connects the dots perfectly back to the James O'Keefe case we started with. What Meg is articulating is that the O'Keefe case is the Rosetta Stone for the public.
Yes, she says it perfectly. What they did to James O'Keefe yesterday, that's what they've been doing to regular people for years. The only difference is now the whole country is watching. Because O'Keefe is famous, because he has a massive platform, And because he has high-powered lawyers filing emergency First Amendment appeals, the national spotlight is suddenly shining directly into the dark corners of the local county court system. The mechanism of the back door is finally exposed in broad daylight for everyone to see.
It really is.
We have covered a massive amount of ground today, diving deep into constitutional law, administrative mechanics, and the harrowing realities of the family court system. Let's bring it all together. We started this deep dive looking at a single, seemingly routine, temporary restraining order filed against a journalist in a Miami domestic violence court.
And by unpacking the constitutional implications of that single document, the impossible reality of a prior restraint on free speech, and the instant suspension of Second Amendment rights without a hearing, we uncovered a nationwide architectural flaw in our justice system.
We followed the data from the Patriot dossier to see how this hidden architecture of unchecked judicial power, originally designed to protect the most vulnerable in our society, has been completely weaponized. We saw how the lack of transparency allows for dual system entrapment, where the burden of proof is inverted and you are forced to prove your innocence. We explored the financial extraction machine that drains family wealth, forces traumatized people to go pro se against state-funded lawyers, and uses the agonizing length of the process itself as the ultimate punishment.
And we examined the incredibly detailed, highly disruptive legislative blueprint designed to restore constitutional due process to these local courts, shifting the paradigm from remove first, investigate later back to the foundational American principle of innocent until proven guilty, and doing it all through rigorous academic data collection.
So here is the direct call to action regarding everything we've discussed today. If you or anyone you know has experienced this kind of unchecked judicial mechanism in any local court system, family, civil, probate, domestic violence, you need to go to standwithmeg.com.
Standwithmeg.com.
Yes. Fill out the survey. Add your story and your data to this national, academically backed effort. Do not let it remain an anecdote. And you can also use the new link system there to download your specific state's family rights report to see exactly how long the delays are and how much wealth is being extracted in your specific jurisdiction.
Because turning the silence into hard data is the only way to expose the mechanism and force the system to change.
Exactly. And I want to leave you with one final lingering idea to mull over as we wrap up. We often think of our fundamental rights, freedom of speech, the right to due process, the presumption of innocence, as absolute, impenetrable shields. We imagine them guarded by the massive fortress of the Supreme Court and centuries of federal law. But what happens to a society when it realizes that those massive constitutional shields at the front door can be completely, legally bypassed by a single local judge's pen signing a routine form on a Tuesday afternoon? If the very foundation of our rights can be so easily eroded in the quiet, closed-door courtrooms originally meant to protect the most vulnerable among us, are we no longer just fighting political or legal battles? Are we witnessing the rise of administrative violence, where the mundane bureaucracy of the system itself becomes the ultimate unstoppable weapon? Take a hard look at the back door. We'll see you next time on The Deep Dive.